Hey everyone, today is Sunday, December 6th, 2020, and hey Trump, affidavits are not evidence. Testimony depositions are. I'm not really sure what your attorneys are doing. I'm not sure that they know what they're doing. But they're filing affidavits, and an affidavit is not evidence. Now, it can be hearsay evidence, but so can a chewing gum wrapper, right? That's not full proof evidence. If it isn't evidence that satisfies the federal rules of evidence, rules 901, 902, 903, having to do with the full proof evidence, then they're not evidence. They're hearsay evidence. And that isn't good enough, right? So your attorneys are doing nothing but filing hearsay, and the judges have said so. And you need to talk to them and say, put in some depositions. So for the rest of us then, what I found out by doing this research over these things is that that's what we should be doing in a court case. The very beginning, pre-trial is during the discovery period. And one of the things in discovery that they don't talk about is doing depositions. And so if you're like a defendant in a criminal matter, you can depose the other party. Well, think about that. We don't even know who the other party is. They never show up. There's just some attorney sitting over there, but it's supposed to be like state of Michigan. Well, where's the injured party? So now you get to file and ask for a deposition, which, well, that's a whole different Ricky Lake show, right? That's playing off a new set of rules. And if you can't do it in your case, under Rule 27 of the Federal Rules of Civil Procedure, you could file one with the district court even though you don't have a court case, just to perpetuate the testimony. And so we'll be looking at that also, right? So this may go on for a bit, but the first thing I want to do is just make it really clear to anybody who may be able to get a hold of Trump or one of the generals helping Trump or somebody and say, look, these fucking attorneys are putting in affidavits and they're not evidence. So let's get that part taken care of first, where that came from. Hey, I'm Staff Sergeant Robert Allen Wertluski, United States Army veteran. I go by the avatar Rob Ryder, and my email address is courtofrecord@AOL.com. My phone number is 616-712-6179. Come on, General, call me already. Let's get this figured out. Hang on, let me go find these pages now. We'll get started. Okay, so these definitions come out of John Bouvier's dictionary. I'll show it to you in a second, law dictionary. Where it says affidavit is practice, right? It's an oath or affirmation reduced to writing. Okay? Sworn or affirmed, too, before some officer who has the authority to administer it. It differs from a deposition in this, that the later, the opposite party has had an opportunity to cross-examine the witness, whereas an affidavit is always taken ex parte. So depositions can have cross-examination. So both parties can do the same thing. And what's a deposition? It's evidence, right? Depositions are, by definition, evidence. An affidavit is practice. Well, it's time to quit practicing and, do it for real. That would be, well, put in some evidence. The testimony of a witness reduced to writing. That's what a deposition is. It's the testimony of a witness reduced to writing. And when this thing is done right in due form of law, taken by virtue of a commission or other authority of a competent tribunal. So in other words, the court appoints people to do these things. Or the statute appoints somebody to do it, or whatever it is, right? They're appointed who can do it, who can take a deposition. And I'll show you who those are in just a bit, but it's different than going to the notary and doing an affidavit. So, right, that isn't good enough, right? That's just hearsay. It's not going to work. You're never going to win. Nobody will ever win filing an affidavit as, their proof, because it isn't proof. It's a frickin' oath rendered to writing. So before it was taken, this is the deposition now. The witnesses ought to have been sworn or affirmed to declare the truth, the whole truth, and nothing but the truth. I got a little problem with that myself, but we can work on that later. It should properly be written by the commissioner appointed to take it or by the witness himself. So who can do a deposition? Let's just start there, right? Well, most people think of court reporters. They can do it. Well, then they have a commission from the court to do that, right? So This is the thing. It's not just anybody. It's specific people that can take a deposition. Depositions in criminal cases cannot be taken without consent of the defendant. And so, you need to say, hey, I want a deposition taken, right? If you don't say anything, they're not going to do it. Silence is acquiescence. Okay, so directs that when testimony of any person shall be necessary in any civil cause, dependent in any district, in any court of the United States, who shall live at a greater distance of can be taken D. Ben Essie before any justice or judge of the courts of the United States or before any chancellor, justice, judge, or supreme or superior court, mayor, keep that in mind, mayor or chief magistrate of a city, mayor can take your deposition, which is really as simple as the Army sworn statement I keep showing with your statement on it properly done. It's a deposition of you. You're swearing to the truth of it. Now, you could also ask questions to somebody else, have them deposed, but you can do yourself. Right? So a mayor or chief justice of a city, a judge of any county court or court of common pleas of any of the United States, not being of counsel or attorney to either of the parties or interested in the event of the cause, provided that a notification from the magistrate for whom the deposition is to be taken to the adverse party, right? So, provided that a notification, right, notice from the magistrate before whom the deposition is to be taken to the adverse party, so you don't send it, you don't send the notice, the judge does, to be present at the taking of the same, and to put it in interrogatories if he think fit, be first made out and served on the adverse party or his attorney, as either may be nearest if either is within 100 miles, place of such caption, allowing time for the attendance after being notified, not less than the rate of 1 day. Okay, a bunch of stuff that goes on and on and on. The deposition so taken shall be retained by such magistrate until he delivers the same with his own hand to the court for which they are taken. So it's not the attorney putting it in the window like he's doing with the clerk. Whoever takes the deposition, they're going to go put it into the court. Or shall, together with certificate of reasons aforesaid of their being taken, and of the notice, if any given, to the adverse party, be by him, the said magistrate, sealed up and directed to such court, and remain under his seal until opened in the court. Well, that's a little more than an affidavit. All right, so let's continue on. Hang on a second. So here's just an example of what's being said about these turds your attorneys are dropping. Right? Evidence, hearsay, voter fraud claims, and affidavits explained. Yeah, well, I can tell you, an affidavit is not evidence. Where did it say that in here? While no hard evidence has been discovered, right? This is the thing. No hard evidence, no deposition during the discovery period has been done yet to support widespread voter fraud claims in the 2020 election. Plenty of people have signed their name to sworn testimony. Well, no, they signed their name to an oath. See, this is the thing. They didn't sign it to sworn testimony. That's a lie. They signed an affidavit, and we just saw by definition that an affidavit is an oath. And a deposition is testimony. Now, if the affidavit is at the bottom of the sworn statement, then yeah, it's part of the sworn testimony, but it's the affidavit at the bottom. And, again, it's on the Army form. Let's just take a quick look, just so we remember, right? Here's sworn statement form, used by the Army. Good enough for the Army. It's good enough for you. In fact, I just did one of these last night, not be getting to it, right? But this is the first page, blah, 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 blah. Put your statement. Get to that when you get done, right? Now, you put your name in, and this is the affidavit, right? The affidavit is at the bottom of the sworn statement. And so what you're doing is you're swearing to the fact that you read the statement, and you agree it's yours and it's true. Right? But up here in this part, all you're going to do is say, I, put your name in, want to make the following statement under oath. And you start putting it in. Okay, well, that's what should be happening, right? But that isn't what's being put in. Affidavits are being put in. So what is the deal with these affidavits? By definition, an affidavit is a sworn statement in writing made under oath or affirmation. I want to see where is the dictionary says that, because it has it in quotes. A sworn statement in writing made under oath or affirmation before a person authorized to do so under the law. But that's not what Bouvier said. He said it was an oath or affirmation reduced to writing. Right? And it's a deposition that is the testimony of a witness reduced to writing. So, in a lawsuit, if a witness offers sworn testimony that is considered evidence, in a lawsuit, if a witness offers sworn testimony that is considered evidence, but the finder of the fact, usually a jury, sometimes a judge, determines the credibility of the evidence, right? Because it was put in as hearsay evidence. Again, it's not sworn testimony. Right? I just don't see how they can say that, because you don't do testimony with an affidavit. You do testimony on a deposition. So technically, yes, an affidavit is a form of evidence, but that doesn't mean it's credible, right? So technically, an affidavit is a form of evidence, hearsay evidence, but it's not foolproof evidence. May decide based on collaborating evidence the credibility of the witness. If there is none, finder of fact could rule insufficient evidence to prove the plaintiff's claims. Well, that's because, again, it was hearsay. So, let me show you that. Hang on a second. So here's an example there. Donald John Trump, Great Lakes Justice Center, right, is doing some paperwork for you in Wayne County, Michigan. They filed this summons for entities that don't exist. There is no Janice M. Winfrey, Kathy M. Garrett, right? They don't exist. That's not their full legal name. Cheryl A. Constantino, right? That's not this person's name. That's not the name on their driver's license. So, John Doe, basically, this is why they're saying that it's not credible, because the woman's not using her full legal name. Right? People are hiding their identity. I'd say it's not credible either. That's what I say about the oaths these people put in. They don't use their full legal name on them. Right? Judges don't use a full legal name. Clerks don't use a full legal name. The person claiming to be the frickin' governor isn't using a full legal name. Goes on and on and on. But in this case, State of Michigan and the Circuit Court for the County of Wayne, which is not the proper name of a court, doesn't matter, complaint. This is all just practice, right? There's nothing, as you can see, there's really nothing filled out. These are just pieces of paper that somebody made. This is all hearsay, right? Truthfully, there's nothing on here that's real. Just all pretend, all practice, all hearsay. But eventually we'll get down here to the documents that they said they were going to file. What's going on here? Come on. Right? Affidavit of Robert Cushman. Now, there's many of affidavits, and they're all about the same, but you can see what's going on. They call an affidavit of Robert Cushman. Well, an affidavit is not evidence. It's not foolproof evidence. It may be hearsay evidence, but an affidavit is an oath rendered to writing. Where a deposition is testimony rendered to writing. Reduced to writing. I think that's what they say. Reduced, right? Affidavit. What this should say is sworn statement, right? Like the Army one did. So if we were going to look at an example of how to do this, you wouldn't have to go any further than look at this form, right? What's the location, the date, the file number, right? That could be the court case number. The location could be Wayne County, whatever needs to be in there, who it is, their address, their full legal name, their statement. Right, but what's all this part called? It's called a freaking sworn statement. Not called an affidavit. It has an affidavit in it, but it's not called an affidavit. There it is, affidavit. They're calling it affidavit. These people don't know what they're doing. Or they do know what they're doing. That's the other side, is they're just Benedict Arnolds. So just get them all in a room with the, I don't know, call it the frickin' Homeland Security, get them all in a room and question them a bit. There isn't any attorneys that became an attorney using the middle initial on their application to the bar or their roll of attorney's name, right? That it would have their full legal name on it. And yet here they're all using the middle initial. This is what spies do. They hide their identity. So that's what we're dealing with here in America, right? You want to help Trump out, somebody tell him that his fucking attorneys don't know what they're doing. They're putting in affidavits. They need to put in testimony. Okay. Where are we going next? Got a few more things to show you, so hang on. Okay, hearsay evidence. The evidence of those who relate not what they know themselves, with what they have heard from others. As a general rule, hearsay evidence of a fact is not admissible. If any fact is to be substantiated against a person, it ought to be proved in his presence by the testimony of a witness sworn or affirmed to speak the truth. And that isn't what you're doing with an affidavit. Right? It's just hearsay evidence. And they have these people doing it using the middle initial name, so they're not doing it as themselves. They're doing it, using a pseudonym. That's why you have a full legal name. It needs to be used in all legal matters. It's really the only time it needs to be used is in legal matters. If it's supposed to be legal, or you dealing with the government, then it's supposed to be in full legal name. And that's not what they're doing. So it just goes on and on. So really what you need to achieve, if you want to put in evidence, is it needs to be full proof evidence. And if you go to the Federal Rules of Evidence, go to section 901, Authentication, Identification in general, to satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it to be. Examples. The following are examples only, not a complete list. Testimony of a witness with knowledge. Testimony that an item is what it is claimed to be, right? What do they call that? Testimony. They can call it affidavit. Non-expert opinion about handwriting. Comparison by expert witness or the trier of the fact. Distinctive characteristics and the like. Opinion about a voice. Evidence about a telephone conversation. Evidence about public records. Evidence about agent documents, evidence about process or systems, and provides methods provided by statute or rule. Evidence that is self-authenticating. The following items of evidence are self-authenticating. They require no intrinsic evidence of authenticity in order to be admitted, right? They are what they are because they are on this list. And so, as I had said in other videos, right, that if you get a record out of the library where they put their stamp on it, well, then that's a public record, right? That's a domestic public record that are sealed and signed, right? So you get them to seal it, put their signature on it from the library, and it's a public record. Domestic public documents that are not sealed but are signed and certified. Foreign public documents. Official publications, trade inscriptions and the like, newspapers and periodicals, acknowledged documents, right? So an acknowledged document is when you have a notary do an acknowledgement certificate But then you have to take and get the certificate of authority for the notary from the county or the state or however your area does it, to prove that the person who said they were a notary were actually a notary. Right? But it needs to be acknowledged. So that's not an affidavit, that's an acknowledgement. Presumptions on federal statutes, certified domestic records of a regularly conducted activity. Certified foreign records of regularly conducted activity. Subscribing witness testimony. A subscribing witness's testimony is necessary to authenticate a writing only if required by law in the jurisdiction that the government governs its validity. Okay. Anyways, right, there's nothing in here about affidavits being foolproof evidence, but testimony is. So how do you keep that kind of stuff? And that's what this idea with the deposition is, right? It's a deposition to preserve testimony. And here's the rule in the federal rules. It allows you to do this. So even if you couldn't do it in your court case, because not all states seem to be doing things the way they're supposed to. In fact, the states have been vacated, so I don't even know that we could count on a state court doing this. But right, Rule 27. A person who wants to perpetuate testimony about a matter cognizable in the United States court may file a verified petition. What kind of petition? Verified petition. In the district court for the district where any expected adverse party resides. The petition must ask for an order authorizing the petitioner to depose the named persons in order to perpetuate their testimony. The petition must be titled in the petitioner's name and must show that the petitioner expects the party to be an action in to be a party to an action cognizable in the United States court, but cannot presently bring it or cause it to be brought. Jeepers. Let me say that one again. The petitioner expects to be a party to an action cognizable in a United States court, but cannot presently bring it or cause it to be brought. So there is no case already in the district court, federal district court. You're just going there asking by petition, verified petition, to take somebody's testimony. All right, the subject matter of the expected action of the petitioner's interest, the facts that the petitioner wants to establish by proposed testimony, the names and descriptions of the persons who the petitioner expects will be adverse parties, and name and address of expected substance of the testimony of the deponent. What does all that mean to us? Well, this is how I think you use this, right? If you're in a court case now, right, that you would send this verified petition to the federal district court, and you want to do a deposition with the guy that's pretended to be the judge and the guy pretended to be the attorney for the plaintiff. Because they're both using middle initial names. Right? And so I say that's what we put down there. Right? And and so what should happen then is you tell them you want to do this, who you want to do it to, and they're going to issue an order and send out a notice to have a notice of service at least 21 days before the hearing date. The petitioner must serve each expected adverse party with a copy of the petition and notice stating the time and place of the hearing. So since there has to be a hearing, now somewhere in between you putting in the petition and sending this notice, somebody had to tell you when the hearing date was. And like with a state judge, you go to their calendar clerk to get a hearing. I don't want to say state judge. The people acting like state judges. You go to the calendar clerk to have a hearing. So whatever the proper way is to do that, somehow you have to get the hearing date first, right? You need to say, I want to have a hearing on this matter, and they look at the judge's calendar and they pick a date, and now you have a date, and it has to be at least 21 days out so that you can do the service, right? But yada, yada, yada. And so anyways, if you were to do this and send it out to the other party, right, that may make them drop the case. Because you could tell them you're bringing them to the federal court, because one of the things that asks here is, well, why are you doing this, right? What's the subject matter of the expected action and the petitioner's interest? Well, I'd say it's civil rights violation or violation of the Constitution, your due process protections, right? Something like that. That's, by my next video, I'll have an idea of how I'm going to do it exactly. But I'm just pointing out today that that's what we're supposed to do. We're supposed to be asking for a deposition, either putting it in our own, as our sworn statement, and then, into your own court case, or if you can't get it done at the state because that's really not the proper court, anyways, they're just pretending to be the court, then go to the federal court and try it, right? Because you don't have to have a court case. You just need to file a verified petition. So, doesn't even say what it costs. It's not like it costs you, like $500 to do a civil action, but you're not doing a civil action. And so I went to look on the miscellaneous fees schedule, and I didn't see it on there, but I do know that when I did the petitions into the Southern District of New York Court, they have a miscellaneous case file cover sheet. And on there it lists the different kinds of petitions. So, it could be put on there. In fact, it might be on there. I have to go look at that real quick. We'll get to that. Oh, let me go do it now. Hang on. Okay, well, very cool. They have one, right? So this is the miscellaneous case cover sheet from the Southern District of New York Court. And petition to perpetuate testimony. An M23. That's what you want to do. I want an M23, please. And all of these things, on this list is like the miscellaneous remedies. And so it's not like doing a civil case. This is a miscellaneous case, right? Miscellaneous case cover sheet. So you don't have to have a court case. You just have to check the box. So now, the problem with this is that not every court has that thing. Right? I've only found one at the miscellaneous or the United States District Court for the Southern District of New York. Right? That's where you find that form. But it doesn't mean the other courts don't do it. It's just they don't advertise it quite as well. So again, it's a matter of filling out the paper. Petition for preservation of testimony. And, then after that, send it to them and game is on. See what they do with it. Okay, hang on. Okay, let me show you a few more definitions. And then just a few more things. But I want to get to something that is of great interest if you're in the military. So hang on here. So first of all, testimony, right? Testimony is evidence. Affidavits are not evidence. And an affidavit is not a testimony. But testimony is evidence, and it's a statement made by a witness under oath or affirmation. Right? So sworn statement made under oath with an affidavit would be considered testimony. Okay, any circuit court upon application to it as a court of equity may, according to the uses of chancery, direct depositions to be taken in perpetuum memoriam if they relate to any matter that may be cognizable in a court in the United States. So that's what we're talking about, perpetuating testimony, which used to be in the circuit court, and then in 1915, they had some Judiciary Act, and they made the circuit courts just the appeals court that they are today, and they took the equity jurisdiction that it used to have, and they gave it to the district court. What is a deposition? The testimony, right? Not the oath, like an affidavit says. It's an oath. No, the testimony of a witness taken upon interrogatories, not in open court, but in pursuance of a commission to take testimony issued by a court or under the general law on the subject, and reduced to writing and duly authenticated. Right? Duly authenticated, which would mean you'd have to get the notary certificate of authority to authenticate it, and intended to be used upon trial of an action in a court. Right, so someday you may have to use this in a court, but today we're just doing the deposition. A deposition is written declaration under oath made upon notice to the adverse party for the purpose of enabling him to attend and cross-examine or upon written interrogatories. So you can do it for yourself, or you can do it for written by answering written questions. Right? But the thing is, when you're going to, so the way they're making this sound in this deposition is that once you put it in, they're going to have a hearing date where the other party can come in and contest it. Right? So anyways, the thing was this commission to take testimony. What the heck is that? Well, in the California Code of Civil Procedures, it says a deposition under this section shall be conducted in either of the following ways. Under the supervision of a person who is authorized to administer oaths by the laws of the United States or those of the place where the examination is to be held and who is not otherwise disqualified under these other subsections. Okay, well, a place is a city. So that's where the mayor can do it. Right? And here in a bit, we'll go and we'll see, well, who's authorized to administer oaths by the laws of the United States. But this is just for California. So that's one way. And the other way is before a person appointed by the court, which is, the most important way. An appointment under the subdivision D is effected to authorize that person to administer oaths and to take testimony. So you would ask the court. You say, I want to do a deposition. Who's the person appointed by the court? F, on request, the clerk of the court shall issue a commission authorizing the deposition in another state or place, another city. Right? Anything other than the city that you're at then, apparently. So in my case, I live in a township. That township should have somebody who can do the deposition because it's my local government. That's my place, right? But the court, which I would call my district court, the traffic court, is in a different township, in the same county, but in a different township. So I'm in a different place than the court is. The commission shall request the process issue in the place where the examination is to be held, requiring attendance and enforcing the obligations of the deponent to produce documents and electronically stored information and answer questions, such as, did you take the oath in 4 U.S.C. 101? Yes or no? Right? Didn't take that oath. They're not, they're not in the government of your state or of the United States. The commission shall be issued by a clerk to any party and any action pending in its venue without a noticed motion or court order. So you just have to ask the clerk, apparently, clerk of the court. Somebody Monday, don't call me, call the clerk, see what they say. And then call me and tell me what they told you. The commission may contain terms that are required by a foreign jurisdiction to initiate the process. Whatever. Just give me, what do we got to do? Give me the commission. Right? What's the clerk going to do? She's going to issue a commission authorizing the deposition in another state or place. If a court order is required by the foreign jurisdiction, order for a commission may be obtained by ex parte application. Oh, there you go. I need an order. Well, then give me an ex parte application. Again, that's, I already closed it, but you can see it on the Southern District of New York cover sheet. You just check a box, right? Fill that form out, check a box, send it in, and that should be all it takes. So CFR 2222, Title 39, which would be, this would be the post office. Authority to administer oaths or function as notaries. Right? The authority to administer oaths other than for employment. The following are authorized to administer oaths concerning matters other than employment. We've got postal inspectors, a member of the board, and postmasters. Where required in the performance of their official duties. So I say it's the official duty of the postmaster to take my fucking oath if I need it done. That's what they're there for. It's the post office. right? The post, that's a military term. It's got a gold fringe flag. It doesn't have a gold fringe flag outside. It's got an American flag outside. But wherever there's one of those flags flying, that's the United States claiming the jurisdiction, right? So the postmaster is supposed to be an officer of the United States, and they should be able to take my oath. Before whom testimony can be taken, issuance of a commission. This is the Surrogate Court Act. This is someplace else. Testimony may be taken within or without the state or in a foreign country by an attorney in addition to the persons enumerated in some other section. The court may issue a commission to a person authorized to take a commission or to an attorney of the state or the jurisdiction in which the commission is to be taken. Right? So again, either, what I've seen so far, what we call state courts, either there's already somebody appointed by the court, or you request from the clerk to issue a commission. Right? And then in Federal Rules of Civil Procedure 28, which we were just looking at this Federal Rules, that'd be, here's 27, right? So, hey, the next rule. Within the United States, in general, within the United States or territory, insular possession, subject to the United States jurisdiction, a deposition may be taken before an officer authorized to administer oaths, either by federal law or by law in the place examination, or a person appointed by a court where the action is pending to administer oaths and take testimony. So, if the clerk of the court of a state court could do it, then the clerk of a court of the federal court can do it, right? They can get the commission taken care of. A person appointed by the court. Well, then, they have to know who it is. Who'd you guys appoint? In a foreign country, yada, yada, yada. All right, Title 18, deposition to preserve testimony. Whenever, due to exceptional circumstances, it's in the interest of justice that the testimony of a prospective witness of a party be taken and preserved, the court at any time after the filing of an indictment and information may, upon motion of such party and notice to the party's order, that the testimony of such witness be taken by deposition, and that any designated book, paper, document, record, recording, or other material privilege to produce at the same time in place. Well, then depose the fucking prosecuting attorney and say, bring all them papers that you say I'm being charged with, and show me that you signed 4 U.S.C. 101. I'd even try to, depose the judge. But, there it is. You can do it. It says you can do it. Now, how exactly it ends up being done, I don't know. But can it be done? Yeah, 18 U.S.C. 5303 or 3503. Deposition to preserve testimony. Rule 326. I think this is in Colorado. Deposition to preserve testimony. That a witness is or will be absent from the state at the time of trial. See, this is the reason you can do this, because one of the reasons for preserving testimony is for the trial. And these trials don't happen, now. I mean, nobody's ever in a trial. They're all in pretrial stuff, right? So, that's why we have to have it preserved, because they may not be here for the trial. You can't say the guy will be alive next year. And that's actually how it's been kind of written in, right? Now, under the UCMJ, back to the authority to administer oaths and to act as a notary. So, hey, pay attention, veterans, right? This is really, really good. The following persons on active duty or performing inactive duty training may administer oaths for the purpose of military administration, including military justice. Well, we're all still in the military, and so we have access to UCMJ, right? None of us ever got a discharge order. You may have gotten a DD-214, and people try to say that that's why you're out, but it isn't. It's not. That piece of paper isn't even a DD-214, except by title. It's not by substance. And, it takes an order. It takes an administrative order releasing you from the custody and control of the branch of service you're in before you are separated from the military. And until then, while you're waiting discharge, you're still under the UCMJ. And under the UCMJ, if you needed to get, if you wanted to file a complaint then, as, what you can under the UCMJ, well, then we need to find somebody that can do it for military justice. So you got judge advocates, summary court martial, adjutants. I have to assume they mean like a state adjutant general, right? He could do it. Commanding officers, so forth and so on, and it goes on, and then, but you get down here to see. The judges of the United States Court of Appeals for the Armed Forces may administer the oaths authorized by subsection A and B. Because B is just for people in their performance of their duties, which isn't what we want them for. Myself, I want them for military justice. And as it turns out, according to this, then I should be able to do whatever I need to do with the United States Court of Appeals for the armed forces. Because I don't have, access to a judge advocate or a summary court marshal or any of these other offices, right? Because I don't even have a freaking ID card. They won't let me on base. So I didn't know that was in here before, right? So I'll show you an example of one that I'm doing right now. But the judges of the United States Court of Appeals for the Armed Forces may administer the oaths authorized by subsections A and B. And so they could do your sworn statement is what I'm getting to. Okay, hang on a second. Okay, I found this online, I don't remember exactly how, but if you were to Google preservation of testimony by means of discovery, I'm sure you'll find this document. 6 pages long, so I'm just going to basically read the whole thing. It isn't that long. It's quite interesting. So these are the things they don't tell you. So preservation, as well as discovery of testimony, is one of the important functions of pretrial procedure. Right? So anything before the trial is pretrial, which is pretty much anything anybody's involved in until you're in the courtroom with the jury, right? It's all pretrial. So anytime during that, the preservation as well as discovery of testimony is one of the important functions of pretrial procedure. It is important that the lawyer have at his disposal adequate means of providing for a contingency of a death or removal of a necessary witness. Since cases are not reached for trial until months and sometimes years after the occurrence of the transaction in question, this is especially true in large cities where a shifting population and where court calendars are so crowded that it is unusual delays of reaching trial. The law has always recognized the need, but the machinery which is to be provided to supply it too frequently has been cumbersome and inadequate. Courts of common law for a long period of time furnished no machinery to perform this function. Consequently, courts of chancery were called upon to supply the defect, such as courts of chancery entertained bills of discovery, which preserved as well as discovered the testimony of adverse parties. Right? It preserved and discovered. Right? So likewise did they entertain bills to perpetuate testimony, to take testimony, D. Ben essay in aid of actions at law, which this D. Ben essay is, I think, for something in the future or provisional or so forth and so on. The purpose of both of the later remedies was to provide a means of preserving the testimony of witnesses generally. In the early part of the 19th century, common law courts were empowered by special statutes to give the same remedy which Chancery formerly had given by these ancillary bills. The statutory remedy became known as deposition procedure. Deposition procedure. Deposition procedure. Is there a deposition procedure somewhere? I don't know, but we should, if you got access to Nexus Lexus or Lexus Nexus or Westlaw or something, look it up. What's a deposition procedure? There has been an increasing tendency under modern practice to combine the methods of attaining discovery and preservation of evidence, respectively. As a matter of fact, there usually can be no discovery without incidental preservation. Conversely, preservation often affords an incidental discovery. Why not, therefore, combine the two procedures into a single one? That's what they did. This is the trend of modern practice. The two developments have removed differences in the two types of procedure, which formally made them assimilation less practicable. At one time, parties to an action were neither competent nor compellable to testify as witnesses, but later this disability was removed. Now, the reason for that is, right, they're not using your full legal name as the party, right? When they say Robert A. Rutluski, that that man, he's not competent and can't be compelled because he doesn't exist. John Doe, right? Robert Allen Rutluski, full legal name. Well, that'd be a different story. When parties became witnesses, in fact, it was necessary as an easy step. When parties became witnesses, in fact, it was an easy step to provide that they be examined as witnesses. There has also been a tendency to make liberal allowance for the taking of depositions of all witnesses on the theory that it is impossible to tell when a witness may die or become inaccessible, and that therefore a litigant should not be required to show the witness is unavailable before taking the deposition. Right? They skirted around these rules that had been in place and came up with a scheme that would, satisfy the law, and they didn't tell us. Because, back in the day you couldn't do it because of these reasons, and they somehow overcame these reasons. It has been thought sufficient to make the unavailability of the witness a condition to the use of a deposition at trial rather than to the taking thereof. If depositions may be taken from both witnesses and parties, and if the right to take is unconditional, a very liberal method of discovering and preserving evidence is afforded. So in a criminal matter, right, there's state of Michigan. Well, there's not the state of Michigan. There's nobody over there, right? There's just a guy who's pretended to be an attorney for the state. Well, then take his deposition. Right? Or put down state of Michigan and put it in. Say, Judge, I need the state of Michigan's deposition, right? And, do it. See what they have to say to it. That's who the plaintiff is, and it says that you can depose the party. So that's what we need to do. Ask for a deposition. If the right to take is unconditional, there is no reason for the court to inquire whether the preservation of testimony or the discovery of testimony is primary objective of the applicant. Now, the other reason for doing this with the deposition is to have your own put in, because, as it said, when you do the deposition, the people doing the deposition are going to keep the evidence and they're going to send it over to the court, right? They're taking it from you and they're going to give it to the court. Well, that's a whole different Ricky Lake show, right? You're not sticking it in the window. So it's all good. So that's actually the discovery, not just my point is that's actually the discovery. Now they're going to discover the evidence because it's going to be in the court. Sent there by the person with the commission to take the deposition. The words of the Supreme Court of Kansas in this regard are classic. Now, the giving of testimony, whether on trial or by deposition, is not a privilege of the witness, but a right of the party. He need not solicit, he can compel. You can make him do it. It seems to us, therefore, that under our statutes, a witness may be compelled to give his deposition, although he reside in the country where the action is pending, in the county where the action is pending. Even though it's in his venue, he still has to do it. It is said that the power is liable to abuse and that witnesses may be compelled to give repeated depositions and still be present at trial. Courts will see that this power is not abused or the time of witness unnecessarily taken. It is also said that large amounts of costs will accumulate. This will not injure the adverse party, for the party taking the deposition, which he does not use, must himself pay their cost. Right? Which he does not use. So apparently you don't have to pay for it if you use it. Is that what they're saying? It is also said that this permits one to go on fishing expedition to ascertain his adversary's testimony. This is an equal right of both parties, and justice will not be apt to suffer if each party knows fully beforehand his adversary's testimony. Right? So you get all the answers before the trial, during the pretrial, during the discovery period. But the discovery that you want to do is by deposition. When first introduced, there was considerable aversion on the part of the bar to the use of deposition procedure for purposes of discovery before trial. Such use of the procedure has been attacked as efficient exposition and as being foreign to the traditional purposes of deposition procedure. Some lawyers have felt that to employ words used by Kansas Superior Court or Supreme Court upon another occasion, that the taking of a deposition of a party in a pending case merely to find out in advance what his testimony will be and to annoy and oppress him, and not for the purpose of using the same as evidence, is an abuse of the judicial authority and process. Because you can imagine if you do this like on the plaintiff's attorney and you depose him and say that you want to, he's going to have to drop the case. Right? You're going to oppress him. He won't be able to pursue you in this, simulated legal process he's trying to do. The hostility on the part of the bar, however, is short-lived once the use of deposition procedure, both to discover and preserve evidence, is given a fair trial. Because again, unless you get deposed and have your statement filed as evidence by the person doing the deposition, right, then it's not going to be evidence. It'll be hearsay. And we need it to be evidence. It has to be done by somebody who's commissioned to do a deposition. Its very reproach becomes its glory. The courts say that the virtue of this device is that it is a means of discovering evidence. It is. If you don't use it, they're not going to see the evidence. The following quotation from various opinions will serve to illustrate satisfaction such use of the procedure gives. The code confers right on either party to take deposition of the adverse party, not merely for the use as evidence, if the necessary conditions arise, but for the purpose of exploration or for ascertaining the facts on which the adverse party relies. This is a very wise provision of the Code of Procedure, taking the place of the old Bill of Discovery and affording a much more speedy and efficient remedy than was given in that mode. Taking the deposition of a party is the only substitute we have for a bill of discovery under our practice. So remember, the state of Michigan attorney, right, the one representing the state of Michigan, so the state of Michigan is that attorney sitting there. You can depose him in a criminal matter. Or the plaintiff's attorney, you can depose him in a civil matter. It was the intention of our legislature to remove every barrier to the discovery of the truth. The common law originally was very strict in confining each party to his own means of proof, and as it had been expressed, regarded a trial as a cockfight, wherein he won who advocate was the gamest bird with the longest spears. It was like trial by wager, trial by war, trial by, there were like 7 kinds of trials back in the day. Trial by ordeal. But we have come to take a more liberal view and have done away with most of these features on trials which give rise to this approach. Effective machinery for discovery and preservation of evidence already exists in all the states which allow the taking of depositions to be an unconditional right of the party and impose limitations depending upon availability of witnesses only upon the use of the deposition at trial. So again, the only thing they can say is, you say, I need to take this man's deposition because he may not be here for the trial. You're not, because you're not in the trial now, right? So, and this went on to say that, half the states agreed, half didn't. The greatest danger incident to the use of ordinary deposition procedure for purposes of discovery before trial is that since it is not labeled discovery procedure, courts and lawyers hesitate to use it as such, right? That's the danger. They don't call it discovery procedure, right? They're not saying that you're doing a deposition as part of the procedure. So there you are, right? I think most people, when you would think, well, we're going to do discovery, right? It would be by subpoena, right? But you need to do a deposition because I think by deposition, as we read earlier, they still have to bring in the records and stuff. So I guess that was all the good stuff. But let me see. It seems rather unfortunate that the committee had no representatives. Okay, anyways, they were talking about they put this committee together and most of them were complaining, but not all those states had this provision. What they talked about here were they made it an unconditional right of the party, right? They put some kind of limitation in. But if that's the case, if your state did that, that's where this Rule 27 comes in. Because, well, then just go do it at the federal court, right? We need to get the paperwork executed to have the plaintiff's attorney, whether that be in a criminal case or a civil case, to have him deposed. And the same with the guy that's acting as the judge, right? If we're taking it to the federal case, then have them both deposed. Because they're not letting you do it down there, well, then they both need to be deposed because it should be your unconditional right to do this. They're not letting you do it. Okay, hey, just one more thing and I'll be done. So hang on. Okay, so just real quick again. So as I said in the UCMJ, this is Article 136 of the Uniform Code of Military Justice, which is in Title 10 United States Code. So Title 10 United States Code Section 936 is Article 136 of the Uniform Code of Military Justice, which is like a chapter of Title 10. And so Article 136 says that judges of the United States Court of Appeals for the Armed Forces may administer the oaths authorized by subsection A or B. And A said for military administration, including military justice. Well, good enough for me. So who are these characters? Right? Well, it's the United States Court of Appeals for the Armed Forces. They don't have a big fancy site like the rest of the courts do, but, you know, that's how they hide it sometimes. And about the court, judges. Who we got for judges? Right? Judges. Got 4 judges now. And so, you know, if you spend enough time with these federal sites or any government site, like if you take this part right here, right, and you put the @ sign before that, and then you put in some version of somebody's name that works at that entity, that will be their email address. So sometimes it would be like Scott.Stuckey, or it could be Scott_Stuckey, or it could be Stuckey_Scott, or, you know, however they do it. All these places are different. So usually I start by taking this much of it, right, with the @ sign, and go put it into Google or a search engine and see if anything comes up showing that any person's name, to see what the style is of the email addresses. And then you can go back and find the people you want to send it to, like these judges here, and you can send them an email. Great system. So that's what I did. I said, okay, well, I'm going to fill out an Army sworn statement form and send it to them. And because I like to make public record of this stuff, I'm going to do it right now. All right, location. So, you know, again, this is me doing mine. Location, Kent County, Michigan, United States. Yesterday at 8 o'clock at night. They want the name backwards. Okay, I'll put it in. Social Security number, veteran, my address, 10955 42 Mile Road Northeast, Rockford. That right there. I was actually told by my postmaster that that's my official address, right? Just like that. So good enough for me. It didn't say to put the phone number in, but I put it in because, well, I can. So I said, right, I, Robert Allen Wertluski, DODID 12112800006, want to make the following statement under oath, right? This is how I authenticated who I was. because your name by itself isn't enough. You need some authenticator. So that's why they use like your driver's license, your social security number, or whatever. Well, because this is military, I'm using my DOD number. I accuse Gretchen Esther Whitmer, accused, who is currently residing at the Michigan Governor's Mansion, 2520 Oxford Road, Lansing, Michigan, 48911, and claiming under the false identity Gretchen Whitmer to be the alleged governor of Michigan and commander-in-chief of the Michigan National Guard of various offenses of the Uniform Code of Military Justice. I'm reporting these offenses. I'm reporting the following offenses subject to trial by court-martial. Charge 1, Article 83, fraudulent enlistment, appointment, or separation. There is no proof that the accused executed and filed the oath in 4 U.S.C. 101, oath by members of legislature and officers, as required by federal law. The accused did, however, file a counterfeit of the oath required by the Constitution of Michigan of 1963. Not only was the style of the oath changed, but it was subscribed under a false identity, Gretchen Whitmer, and administered by a class of officer, Notary Public, unqualified by state law to administer an oath to the governor. Her omission of the one oath and counterfeiting of another are crimes against the United States. Her deceit has resulted in a vacancy in the office of Governor of Michigan. Her fraudulent appointment as the Commander-in-Chief of the Michigan National Guard, and the willful obstruction of a Republican form of government guaranteed to every state in this union under Article 4 of the Constitution of the United States. Charge 2, Article 106, spies, specification. The accused conceals her true identity and lurks in the Michigan State Capitol building as Gretchen Whitmer, usurping the office of Governor of Michigan and Commander-in-Chief of the Michigan National Guard, to access classified information and state secrets during the declared armed conflict in order to sabotage the one nation under God and embezzle the wealth of the people of the state of Michigan. Charge 3, Article 107, false official statements. Specification. The scores of executive orders issued by Gretchen Whitmer as governor of Michigan are false official statements that were created as part of an effort to coerce the civilian population of the United States or to influence the policy or affect the conduct of the United States government by coercion. That'd be the end of my report. Call the accuser, that would be me, to administer the required oath. Nothing follows. All right, I had one exhibit, counterfeit oath. Got an initial with the pages. Right, I really don't have a second page, but I do have a third page. So now this is where the affidavit is, right? Here's the affidavit on the sworn statement. I, Robert Allen Orlowski, DOD ID, number 12112800006, have had read to me this statement, which begins on page 1 and ends on page 1. I fully understand the contents of the entire statement made by me. The statement is true. I have initialed all corrections and have initialed the bottom of each page containing the statement. I have made the statement freely without hope of benefit or reward, without threat of punishment, and without coercion, unlawful influence, or unlawful inducement. And I signed it. And I put in one exhibit, which I've shown this numerous times, right? So this is what she filed. And I've asked, when I did my Freedom of Information Act to the place that's supposed to have the oaths of the governor, right? The election office for the state has all the paperwork for the state officers. I said, send me the oaths filed by, Governor Whitmer. And this was the only one they sent, which means, because this isn't the one for Title 4 United States Code 101, right? It's an improper oath. Well, apparently she didn't do it because they didn't send it to me. But what it is, it's supposed to be the oath that is in the Michigan Constitution, and, it isn't. It just kind of looks like it. So what's wrong with it? Technically right here, Constitution of the state. This should be lowercase c, lowercase s. right? This making that Constitution of the state proper case the way it is totally changed the grammar of and the meaning of this oath. Plus, she didn't do it as Gretchen Esther Whitmer, right? So she's hiding her identity, and it was done by a notary, and notaries cannot do the oath of a governor. It's Michigan MCL 15 point something or other. I don't remember the exact numbers now. Right? Capitalization of the oath. Text is different than prescribed by the Constitution of Michigan. Gretchen Whitmer is not the true identity of Gretchen Esther Whitmer, and state law prohibits a notary public administering an oath to the governor. And as it turns out with these characters here, it's just a matter of, well, in fact, I did send the email. Here, let me go look. Yeah, here's the email I sent. Specification and charges accusing Gretchen Esther Whitmer of violation of UCMJ. And you have to put a dot between their first name and their last name. At, and then whatever that blah, blah, blah was for that particular unit. This happened to be the appeals court. Judge of the United States Court of Appeals for the Armed Forces, in accordance with the Uniform Code of Military Justice, Article 136, authority to administer oaths and to act as notaries. The Judge of the United States Court of Appeals for the Armed Forces may administer the oaths authorized by subsections A and B. I am submitting specification and charges, probably should be charges and specifications, for violations of the Uniform Code of Military Justice by Gretchen Esther Whitmer, a.k.a. Gretchen Whitmer, Governor of Michigan, on an Army Sworn Statement Form, DA Form 2823, to the Judges of the United States Court of Appeals for the Armed Forces, for one of them to administer me any oath required for my sworn statement of specification charges to be in due form of law for the purposes of military justice. I await said judge's execution of their duty. So I'm waiting for a phone call. So that was one way to use it, right? I'm saying, well, she's the governor, claiming to be the governor, is ex officio then, the commander-in-chief of the National Guard. Well, that makes her subject to the UCMJ. I don't need to try her civilly. I can try her militarily. And so you could take that farther and say, well, anybody who's sitting in a room that's got a gold fringe flag, you could take them under the UCMJ. Take your claim against them under the UCMJ that they're violating one of the provisions of the Uniform Code of Military Justice. And I'll do more of that on another video, but I just wanted to point it out that, hey, for veterans, we may have another avenue to get our sworn statements done, right? Because, let me show you the one that I've already done that I want to do again that has to do with, the fact that we haven't been discharged from the military yet. Now, hang on. Yeah, it's Article 139, redress of injuries to property, where a complaint is made to any commanding officer that willful damage has been done to the property of any person, or that his property has been wrongfully taken by members of the armed forces. He may, under such regulations as the Secretary concerned may prescribe, convene a board to investigate the complaint. So that's what I'm trying to file to them. They're supposed to be able to handle the stuff for military justice. These judges at this court. But in this case, using this section, 139, it would be because we haven't been discharged, right? And so we're not getting, myself, I don't want to be discharged. I just want them to acknowledge I'm still in and give me my ID card, my Geneva Convention ID card, and all the back pay they owe me because they never discharged me. All right, I'm happy to keep the card and take the money, right? Because, the elections are just simulated legal process. There really isn't any election. The United States is still under martial law. It has been since 1861. And if it's a military government, then it would be good to have a military ID card, right? And then the veterans become part of the government, and we become the eyes and the ears of the commander-in-chief out in the districts. And we keep all these people that are supposed to be doing these functionary jobs in this provisional government of the United States, while it's under martial law, all under the Lieber Code, right? Just whatever the Lieber Code says, what they did. Well, then, we should be making sure they're doing it right. It's just over time, esquires have gotten a hold of the system and they've corrupted it. And we need to bring it back somewhere closer to center. So, okay, here you are. Trump, affidavits are not evidence, but testimony depositions are. And that's what we need to be working on. Okay, y'all have a great day. Hope you found it useful. See you.